mandatory data breach notification requirement is a pretty big step. It's common in the United States. Most US states have it in place. We don't in Canada. There have been those that have tried to argue that the current law with accountability principles could be incorporated to include that kind of requirement, but not everyone's convinced, and I think that's why there's the sense that we need something quite clearly in the legislation to make it a mandatory requirement. It would actually envisions a two-stage process. The first step is notifying the Privacy Commissioner, Federal Privacy Commissioner, of the breach, and there's a particular standard for that notification. Where there is the risk of significant harm to an individual, then that moves into sort of, in a sense, the second stage, which would be the notification of the affected individuals. I think it's a very positive step. There have been some concerns, and I've expressed some concerns about some of the standards that are included, and even more, I think, the absence of any real penalties associated with data breach. But at least moving forward with that, and perhaps having the opportunity, if the bill goes to committee, to raise some of those concerns and perhaps tweak it a bit, I think is potentially on the table.
And
if there are no penalties associated with it, the danger is we're going to get some organizations that are going to do essentially a risk analysis as to whether or not to disclose. And part of that analysis is, well, what's going to cost me if I don't disclose? And basically run the risk that, perhaps this information won't be misused. Maybe it was just, it happened. We happen to lose this, but perhaps nobody will be affected by it. And so we'll, in a sense, run the risk that that's the case. And we don't face any penalties if we don't disclose anyway. I think that's a problem. I think that, from my perspective, it's quite clear we need to have real penalties. So part of that risk assessment is there is a real cost associated with not properly disclosing. And this comes up in a couple of different ways. First off, we've got a number of courts that have set an incredibly high threshold for awarding damages under existing privacy legislation. So the violation of the privacy rules has to be egregious, has to be intentional, in order for a court to be willing to assert damages. There's almost no case that that's going to happen, where it was you intentionally lost someone's data. So the prospect of a court awarding damages is very, very low. And we can talk about both damages in that context. We can also talk about damages for the failure to notify. And in some ways, that's an easier one. Surely, if we set the requirement that you've got to notify, there should be a penalty attached if you don't. And at the moment, there isn't. Essentially, the only thing we can do is rely on the potential for damages under PIPEDA. But as I just mentioned, the reality is courts aren't awarding damages for violations of PIPEDA. So we're left with this difficult situation where it's unlikely that we'd see any sort of penalties for a violation, and there are no provisions for a penalty for failure to notify.